That will do very nicely, Wes. Thank you.
Don't worry, I'll make it better.
You wouldn't. Lovely.
We are live right now. Where? Okay, it stopped. Yeah, I'm not directing this, by the way, so one of y'all need to take lead. I guess I can do that. Oops.
Okay, seeing as it is currently 2:32 p.m. Eastern Standard Time, we will be beginning the hearing, and we will be doing that by having me, the lovely man I am, reading off the indictment. So, on February 9th, 2020, at 5:29 p.m. Eastern Standard Time, the court ruled that, in a unanimous 4-0 ruling, that the ministry was in contempt of court. They then gave the legislature the authority to proceed with the impeachment of the ministry.
The legislature also voted to indict them all.
Yeah, well, that's a whole complicated mess, isn't it? Anyway, we I'll begin by opening the floor to any quick pre-opening statement motions in case either the prosecution or defense has something they want to change about just how they're running their case. And then we can begin with. Okay,
You can
yeah,
proceed.
Wes, just make sure that the impeachment hearing channel is on screen for the duration of this. Please don't ping Wes because it'll make him sad and then we'll have issues. But yeah, if you just keep the screen layout like that, then all right. By the sound of it, no one has a significant motion that should be made at this time. So we will proceed with the prosecution opening statement. As the prosecution statement is being typed, I will read it off. It is in the belief of the prosecution that, through malicious intent of some and negligence of others, the members of the defense violated the law in an egregious manner. In specific, the prosecution holds that the defense simply elected to ignore the court rather than resolving their legal dispute through proper channels in an attempt to abuse the judicial system. While some members of the defense, we believe, were unaware of this, it is their responsibility to be aware of ongoing legal disputes of this nature and attempt them from spiraling out of control in this way. To clarify my accusations, Ken Lane and former Prime Minister Wes seem to have conspired to drag out the legal battle over Carthago Nova and abuse the supposed lack of court authority to hold Carthago Nova indefinitely in a direct violation of court order, while other members of the defense did not do their due diligence to prevent this action from happening. Thus ends the prosecution's opening statement. Thank you. We will now move on to the defense opening statement. Ken, if you'd like to go ahead and...
Absolutely. Thank you, Angus, for moderating this whole affair. I want to thank everybody involved, including the legislature, for taking the time to listen to me talk to them today about this issue. And it's a very important question that's being asked right now. And it's a very important question because it's going to set a precedent for what is grounds for impeachment inside of our democracy. And I think Lady Sale has oversimplified the issue to the point where it's black and white in her mind that by violating a court order, we are guilty. Without any evidence of it, without any consideration for the circumstances, without any consideration for what the will of the people had, because we violated a court order that is questionably legal, if the court has the authority to issue such an order and force another branch of government to resolve an action, that by violating that, we have somehow done something that is unforgivable and impeachable. However, that wasn't the first time even that the ministry went against a court order without an injunction. But the first time it wasn't considered impeachable. Why was that? Why were we not impeached the first time? Why the second time? Perhaps it's because, if you were like me, you believe it's because they saw this as their only hope of ever winning the argument on Carthago Nova, a city that 98% of the people voted to keep in a referendum that was legally binding, that the ministry was obligated to follow. Had we given Carthago Nova back, we still would have broken the law. There was no winning move here. And so we chose to do what we were elected to do and follow the will of the people. I think you have to really ask yourself, what is the burden here? What is the burden of proof that Lady Sale must achieve? Is it enough to state that there was a court order and that we didn't return Carthago Nova? Well, if that's the case, we should have been impeached weeks ago. You need to have in your mind doubt. And if you have doubt, you cannot impeach this ministry. If you have doubt that we were acting in a way that was unbecoming, if you have doubt that what we did was actually illegal or more illegal than keeping the city, if you have doubt that the court cases were not fully resolved and that there should have been a future case on the outcome of the referendum, then you have to acquit us. You can't find us guilty if there is reasonable doubt that we were acting in good faith. Why was it not illegal? I've already gone into this a little bit. The idea here is we had outstanding legal reasons in order to take these up in court. We felt like we needed to wait on the referendum results. Had the referendum results come back saying, nah, you know what, nobody wants to keep the city, we would have totally been willing to give the city back because that's what the people wanted. But a small minority of people, about 3%, leveraged themselves inside of our legislature and in the court system in order to have their will imposed on what was to be done with the city. We didn't abuse the court system here. They abused the court system. I don't want to take up too much time with all of this, but I have to mention as well the ordering of events here. And so I'm going to submit into text a timeline of events with some, what would I call it? A timeline of events with, oh, that's too large. Okay. A timeline of events of what happened and how this whole process unfolded so that everybody can see exactly what we are voting on here. Let me delete that guy.
Wes, please open the files that
I'm going
Kim was
to read through it as well, but I am going to also submit it there so that there's a written document of it. So prior to the start of these court cases, there were two laws passed congruently. These laws appeared to have conflicting definitions of occupation, at least as how I read it at the time. Furthermore, their simultaneous passage raised questions if one definition should apply in the other bill. You can imagine that people who were writing these bills may not have been talking with each other. They may not have understood what the operational definitions of the other bills were. And so it may not make total sense to try to apply one definition wrote across both bills, given that they were passed congruently. And so then on January 12th, Sale sued the ministry for the first time. And then on the 15th, the court case opened. And on the 17th, there was the last comment. At this point, I believe the case is open for at least another 24 hours before they close and start deciding things. During the case, the legislature took notice of what was happening and how the two laws were seeming to conflict. And at that point, the legislature, a majority of the legislature, took action and decided they wanted to keep Carthago Nova, or they wanted to give the people the option to keep Carthago Nova. And so they passed the Carthago Nova Sovereignty Act in the legislature before the court case even closed. They passed the Carthago Nova Sovereignty Act, and then 48 hours it passed the ministry because we had some abstentions. And so the Sale v. Ministry closed at some point congruent with that. And after it had passed the ministry, the ruling on Sale v. Ministry had been issued. 3-0 of voting judges found in favor of Sale, one judge recused, and I believe one abstained. So at this point, we have now a court case and a law that did explicitly issue itself as being retroactive. A law that explicitly said it had to be followed, where we have to hold a referendum and have the outcome of the referendum determine what happens to Carthago Nova. what are we supposed to do? Well, the referendum's supposed to be held within 50 some odd hours. So we decided that we would wait for the referendum before we made any action on Catharga Nova. And here is the next step of things that I promised. And so we effectively adopted the policy of let's legal options in order to see what we can do in order to overturn the ruling so we have only one ruling on Catharga Nova. And so we filed actually an appeal. The appeal was agreed to be heard. At the time, I did not do my due diligence of reading the court procedures, and I thought I could only appeal on procedure, so I did. And of course, we lost that appeal. It wasn't a real appeal. It was something that we did without really knowing what we were doing. It wasn't the best appeal we could have made. So on the 21st, Sale v. Ministry opinions are released. And then the injunction portion of the court procedure is enacted around this time as well. So injunctions still weren't even a thing, although there was a huge debate in the first session after this whether or not we actually needed an injunction. But we'll get to that. I believe this one hasn't been posted yet, so let me toss that out there. All right, on January 21st, we submitted our second court case. WesGutt submitted this one on my behalf as I was busy this week doing things and I was not going to have time. So January 21st, West v. Punic War Act submitted. The whole point here was we wanted to try to figure out if there was another legal option for us to keep the city, where possibly the actual law that was written requiring us to return the city would count as a trade deal, which the legislature doesn't have authority to do. The court at this point started acting hostilely and didn't fully want to hear this case, but ultimately did. We lost our appeal on Sale v. Ministry about a day later. And then about 3 days later, West v. Punic War Act was actually opened. And at that time, a day later, Session 2 is held by the executive. It's important to note that during Session 2, we had no legal authority to keep that city. There was a court ruling against us. We didn't get an injunction, or maybe we did. I don't actually remember if we had an injunction at this point, but I don't think we had one. And it was a thing. We didn't get sued over it. We didn't get impeached over it. So there's a precedent here that you don't have to follow the court. The legislature already set that precedent. Never mind, they set that precedent when they failed to impeach him after he was found guilty of being derelict in his duties as prime minister. This is not a fair trial. This is the acts of a small minority of people inside of our government trying to overrule the majority by legal trickery. And they've admitted it dozens of times. So West v. Punic War Act closes. Session 3 is held by the executive. The ruling is released. However, opinions for this ruling have yet to be released.
Objection.
This time, I'm sorry? Lady Sale has objections.
Please.
If this is about my comment that they have... Yeah, I'll withdraw that comment. Fine. They have never publicly admitted to having a conspiracy, but it's pretty obvious when 3% of people are trying to overrule 97% that something's going on. So at this point, Wes and I, after the ruling is released, we had a discussion. We finally had our referendum coming into place. We had to push moderation to get the referendum going. It's something that had been delayed and delayed and delayed. But we finally had a date for the referendum. And we agreed that we wanted to file for a new case. We actually decided that maybe we should just try to appeal this case, that maybe in an appeal we can actually get a better sort of reasoning. We appeal West v. Punic War Act, and the appeal is voted down by none other than Masenko and one other judge. Masenko was, of course, the judge who, was, of course, the lawyer who argued for the Punic War Act inside of the previous case, making him not necessarily impartial or unbiased inside of his judgment not to hear the ruling. Furthermore, it wasn't necessarily clear that he had understood the ruling based on his arguments that he laid out.
Wes, Ken, I am going to pause you for 1 second here just to say that I would have sustained said objection, and please do not assume facts not in evidence.
Absolutely, Your Honor. I'm sorry. Heat of the moment. So we appeal the Punic War Act. Misenko and Salas voted not to hear. They voted not to hear when Misenko knowingly had legally argued on the case previously. This is, of course, a questionable denying of the court case, right? Because you shouldn't be ruling on a case when you were already involved in it. We have pointed this out in the past that this is, possibly why he voted not to hear it, is that he had argued for it, but we don't really know. The problem is that we get this ruling, right, on the 9th, that it was denied, and on the 9th, we had a session. We knew we had another lawsuit we wanted to file. We knew what we were talking about. We knew we had a referendum days away that we were going to have to follow. What were we supposed to do? Yeah, we could have filed a case. We could have gotten an injunction. We didn't really have time to file a case and file a good case and get an injunction prior to that session. It just wasn't feasible. We didn't flagrantly disobey the law. We just tried to enact the will of the people as best as possible. And so in summary, I just want to point out what happened here, what really happened here. A bill passed before the court ruling that gave an apparent conflicting orders from the legislature and from the judiciary. It's not clear the judiciary can order us to do anything anyway, and now we have orders from the legislature that conflict. I have to think that the ones that come from the legislature based on the will of the people is what we have to do. A clause in the Constitution that seemed to make at least one of the court rulings that the court ruling seemed to violate, where we do have play over game stuff. So that makes me wonder if they actually have that authority. We have the precedent. We had held a session before where we kept Carthagonova with no injunction on the grounds that we had a legal argument coming forth in front of the court soon. That should be enough for us to, at that time, hold Carthagonova until such time we have a chance to file and have our court case heard. And then there was apparent conflict of interest here. Misenko shouldn't have been ruling on that appeal. He should never have been voting on that, but he was. So in summary, were we really the bad guys here? The people doing the will of the people, what 98% of people voted to do in a referendum? People who were just merely exploring every legal option available to them under the law? Or is it the people who decided to use the court, use their impeachment power, and use their legislative power to enact the will of a small minority of people who voted in that referendum? With that, I am going to end my opening statement. Thank you.
Thank you very much, Kenlin. Before we begin testimony, I would like to comment on Sale's most recent comment in the impeachment hearing channel. The objection that I said I would sustain concerned citation of a potential conspiracy, not the idea that there was a minority for returning Carthage. That was shown by the referendum, so I will allow it. All right. I will now open this up to the prosecution to call their first witness. Sure. Go ahead, Miss Say. I think it is important when we move into this impeachment to consider the motives of each minister. And I do not say this even in a purely accusatory way. Please consider the difference between negligence and malicious action
Say
when
this in a purely
Objection, Your
accusatory
Honor.
way.
Relevance. What does this have to do with the
Please consider the
witness?
difference between negligence and malicious action when voting.
Evidently nothing, Ken. However, I will allow you to respond to it before we call Peppeghetti.
Getting to it. Consider the difference between this ignored court order and the last, which the ministry was not impeached for. That there was no ongoing case whatsoever when this action was taken. In relation to this, the defense has previously stated that they already had a legal argument when going into the session, which they acted on. I would like to ask Pep to clarify some statements made during the stream.
All right, there will be an opportunity of that. Because there were argumentative statements in your above statement, I'm going to give Ken a brief opportunity to respond to this. And
I
then
will briefly respond that I object strenuously to having any witness speak to the motive of the ministers, especially one who has not spoken with the ministers about the ongoing legal battle surrounding Carthago Nova prior to the actual session. Secondly, I will point out that we did not even have a court case filed the first time around, and Lady Sale pinged me mid-session while I was filing the case actively to inform me that she believed we would need an injunction in order to prevent such legal actions from happening, which I never once saw. So I don't know where they're getting their facts from. There wasn't a case readily submitted. I was hastily putting it together mid-session. So I think if we're illegal here, we're illegal there. But I think I will hold any other comments until my cross-examination.
in that case,
In the interest of time.
prosecution, call your first.
Yep.
Ms. Sale, your video evidence will be presented after testimony, as you did not make a motion to move said video evidence to before testimony after I made the evidence schedule available in the proper channel.
Video 1 says, Pep says, aren't we supposed to give CN back? I don't know what video 2 was, though.
But yes, I did several times, I think, ask about the legality.
Ms. Sale, please question the witness.
Did you receive any PMs or any other responses not available in stream to these? I don't think I did. Certainly not to my recollection.
And also, I'd just like to butt in quickly to say, Governor Peppeghetti, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you whatever deity or moral concept you...
Yeah, I do.
Thank you very much. Please answer the questions again, just to make sure that your answer doesn't change under...
Okay. No, to my memory, I did not receive any PMs or other responses not available in stream to those questions. Was there a meeting you were party to beforehand that could have answered these questions? No. I mean, the executive branch typically is in voice chat for a few minutes before the stream starts, but I don't think that's what you mean. We weren't discussing it at that point. Right. It was not discussed at that point. So, yeah. No, there were not any mentions of the legal argument brought up before it was mentioned audibly during the stream. Is there anything else I have to do, Angus?
As there's no more questions from the prosecution, Ken Lane, this is, Governor Peppeghetti is now...
Thank you. Peppeghetti, can you remind me what was your role in the government of Arabia at the time?
I was governor of Medina.
So would you say that it was part of your job to know and understand the legal interests surrounding Carthago Nova, or was it your job to understand ministerial procedure about discussing the legal issues around Carthago Nova?
Nope, neither of those.
So would you be willing to say that it's likely that there were discussions that happened that you were not privy to?
It's possible. I wouldn't know how likely it is.
It is possible, and we will show later, in fact, we did have a discussion. What time did you enter the stream that night?
I don't remember. Usually it's 5 or 10 minutes.
Session?
Well, sorry, say that again?
How long before the session, do you recall?
Probably 5 or 10 minutes.
And recently there has been a trend of people sitting before sessions for much longer during, or at least during that administration there was, about 20 or 30 minutes.
Is that a question or a statement?
Is that correct? Are you aware of that people had been showing up prior to you?
Yeah, I don't know how many people typically, but I am aware that...
Do you remember who was
30
already in the chat when you arrived that day?
I don't remember.
So what do you actually remember about the events leading up to the session?
Leading up to it? Nothing.
The discussion leading up before the session.
I don't remember the discussion at all.
Do you remember anything about the discussion after the session?
Little bits and pieces, yeah.
And who was generally there for that discussion?
Me, you, Wes, Sean,
Charisarian?
Sorry, say that again?
Charisarian?
Right, yeah, he was there.
And who primarily were asking questions?
I mean, Char and Sean and
And who were primarily answering questions?
I think you and Wes, maybe?
And do you remember what those questions revolved around?
I mean, most of it was little foggy, but I'm pretty sure most of it was just about I mean, a lot of it was about how it, okay.
I don't know unless you answer.
Yeah, I'm sorry. I'm thinking it's. I mean, a lot of it was Sean and Char talking about how discussing with you that realistically you should be following the court order. You were disagreeing with that.
And why did we disagree?
I mean, mostly for the same arguments you're giving here, as far as I can recall.
Could you highlight a few of them for posterity, ones that stood out?
All right. I guess the biggest one was that there was a referendum done roughly at the same time as the court hearing, the most recent court hearing, if I recall correctly, regarding Carthago Nova.
So you're saying that after the session, immediately after we had come to you inside of this discussion, or you had sat in on this discussion where we were questioned on the legality of Carthago Nova, and the first thing we brought up was, in fact, that there was an ongoing referendum that disagreed with the court order.
I believe that's correct, yeah.
So would you say it's fair to say that that was a thought-out idea prior to the session?
I don't know if that's fair to say. Could be.
But it certainly seems possible that we had some discussions previously on this issue.
Yep, seems possible.
And is it possible we had these discussions with other members of the ministry?
Of course it's possible, yeah.
What other issues did we raise? Or what other issues were asked of us, if you remember any?
Don't remember any other specifically.
All right. Thank you very much. You're free to go. Or I guess that's for Guild Daddy to say.
Thank you very much to both sides on that testimony. Peppeghetti, you are now free to go unless there comes a time where the prosecution or defense would like to call you back up on the stand. But I do not believe that will be happening.
Excellent. I'll just wait to see.
Lady Sale is typing, so.
I don't think that'll be necessary. Awesome. See you guys later.
Lovely. So the next evidence to be presented will be the videos from the stream, the clips from the stream, that Lady Sale will be presenting on behalf of the prosecution.
If you want to post links, I can pull them up.
I would like to motion that the videos be entered into the record and not viewed immediately for the sake of time, but that then legislature may go back and view them themselves while doing their due diligence.
If Lady Sale has any specific things from this video evidence that that should be looked at, then I will think about seeing that. But that motion sounds like quite a good idea. Then.
Oh wait, the stream can hear me if I do this.
We're a Robot, are you available to read for Miss Sale?
Yeah, sure.
Thank you.
Let's talk about a few of these things at a time. Let's start with the bits in relation to Pep, since we just spoke to him. I do not actually contest that the defense held a secret meeting in order to organize their defense.
Objection, Your Honor. Referring to the defense as the defense before a crime was committed assumes guilt, and that is bad terminology. It should be stricken from the record.
Sustained. Please refer to the side that you are referring to as the defense as the ministry until after the Supreme Court found them in contempt.
But not all of the ministry is the defense, correct?
4/5 of the ministry are the defense. The fifth one was not indicted because they were not there. Their proxy was not indicted. However, if the statement is, I do not actually secretly deny their legal arguments in terms of prior to us maintaining possession of Carthagonova in session, that is fine to say. But in saying that we were the defense at that time and we were organizing our defense implies not only that we intended to commit a crime, but it implies that we had already committed a crime and were already.
We're not the defense at that time, no. I am referring to the current defense as a group. If the moderator would prefer me to reply to you as the previous ministry, I shall do so.
That would be lovely, Miss Sale.
Previous ministry may indeed have congregated before they performed a deed they knew was likely to result in a court case, as consistent with their arguments, as they apparently believed they would be breaking the law no matter what, and planned out their defense in that case, as well as legal reasoning for their actions.
I object on the grounds of relevance. It would seem reasonable. It seems like this also counteracts our previous witness that essentially said it didn't seem like we had any previous discussion about the legality of Carthagonova. Certainly, Lady Sale has got some point here.
Didn't Pep say that he didn't really remember what you discussed?
I mean, I'm quite confused as to what you're saying as well. Can you...
Miss Sale, could you just proceed? And if this doesn't go anywhere, then I will stop you and we'll move on to defense test.
However, at several points during their actions, they are questioned as to the legality of their actions, as you heard from Pep earlier. Their first response was not to explain, but rather move on to other topics or just fail to respond at first. As you can see, In the videos, Wes mumbles something that seems to be equivalent to a bit and just moves on to moving workers and stuff.
Sale, could you comment quickly on just how long is that clip gonna be? Because if it's under like a minute, then
In
we
the
can.
clip, PTP says the leg didn't say we have to give it back for free. Afterwards, Pep says that actually they did say you need to give it for free.
Wes, could you play the clip just for reference?
Yeah, okay.
Hey guys, I just
So-
realized something. Are we supposed to
Wes,
give
you okay?
Carthago back for free?
No.
Oh, that's Jam. Jam, my dude.
So,
Okay, what the
here
fuck
is
is
According
that?
to
Come on.
Jam.
Jam, you sound real cursed right now.
according to them, we were supposed to
Okay,
give that city back for free.
Let's have a discussion. Okay. So we could probably get a research agreement with Germany. They just don't have enough money.
say we have to give it back.
They have fucking swordsmen, so they desperately need research. Since they are apparently one of our more reliable allies, since China and Indonesia are trying to pull some shit, I suggest we pay them, we just give them 300 gold, and then do a This seems to be everything that's relevant.
I'm not getting audio on that, so
You didn't hear
unless the ministry is just being very quiet at this point, which I think the whole point is that they aren't.
Okay, everyone be very
Um,
quiet for 1 minute.
We can just go
Yeah, I'm
off
down with that.
of what Miss Sale
Oh,
is saying
they don't have
in
a
the
text for
clip,
it.
and if Ken has any objection to those statements, he can go ahead and make that.
I would object to the relevance. How is this relevant in proving that we knowingly and willfully disobeyed the law?
The relevance is that you need to give Carthago Nova back for free, and Wes attempted to trade it for gold, which is not free.
Well, we were not aware at the time that it was supposed to
That
be
has
free.
nothing to do with this clip. What are you
And it
talking
has
about?
nothing to do with this clip, actually.
I will proceed to read for Miss Sale because Robot is no longer available, unless she'd like to appoint. To which, rather than a legal response, Ken makes a crass remark that seems to imply an impossibility of prosecuting them.
Should I play this clip?
That'll be alright. Wes,
In the
we'll
interest
just
of
go
time,
for
we
what-
really should just continue. We're almost an hour in.
I think it wasn't working because y'all have the stream muted, so you wouldn't be able to hear this clip, but
Oh, that sounds likely.
because it's showing up as audio on the
Let's just
OBS.
proceed.
Okay. I just think it's fair to give the actual evidence instead of interpretation of it. Okay.
The evidence will be made available for legislative consideration during the 24-hour debate period. If it doesn't seem to be working, there's no point. So at this point, it seems likely the ministry is attempting to succeed legally rather than seek advice or mediation on what and do what is legal. Otherwise, it seems strange to reply to the court telling you that you need to comply with their order with, quote, eat my ass, rather than your legal argument.
I object. I wasn't replying to the court. I was replying to Nim, somebody who had shown bias previously and, frankly, can still eat my ass.
That objection is sustained. Nim is an individual, not a representative of the Alright. It seems strange to reply to a justice telling you that you need to comply with their order with eat my ass rather than your legal argument, as well as dodge the question repeatedly throughout the course of the session. Thus, I feel it is important that we distinguish that the ministry is not attempting to comply with the law in whatever way is legal, but attempting to prove their actions are legal.
Sorry, I gotta object again. I actually rewatched the clip. I didn't say eat my ass. I said bite my ass. So please at least get the quote right if you're gonna quote me.
Objection sustained. There you go. However, way back during the Punic War, we can hear members of the ministry discussing that they are willing to brazenly break the law in order to take Carthago Nova and then fight it in court. Oops, wrong paste. And then there's another video clip that we...
relevant clip. It doesn't take that long.
Go ahead, stream the...
I think we should take that city and then fight it in court.
I mean, yeah, perhaps. I think it's the right thing to do, to take it and give it back to Carthage. Like, you can't.
I don't think it's like if Indonesia is going to occupy Carthage, I don't know.
I mean, like, a past. Would you like that?
I can't
more?
see Indonesia keeping that city. I'll be honest.
He will easily keep it. He's an AI. Seems to be discussing taking the city in order for Indonesia not to get it.
Furthermore, we were also debating whether we would fight it in court or actually return it afterward. It was something that never really had to come to fruition, however, ultimately because Carthago Nova was given to us willingly.
Motive is extremely relevant. It is of note that attacking and taking Carthago Nova by force was explicitly illegal at the time. I will not comment on the results of the last court case. The point of this clip is only to point out that the ministry has shown that they are willing to break the law when it benefits them, not the legal arguments that erupted around Carthago Nova during that. Nor am I accusing you of doing it at that time. Misael, I think you've made all relevant arguments pertaining to this clip, so unless you've got some new direction to go in, we can move on to either your next clip or the defense.
Objection. It clearly shows the intent to prevent Indonesia from taking it, not that we were willing to take it merely for our own benefit. Furthermore, I will point out that the ministry maintains that we repeatedly acted on the behalf of the Arabian people and what was in their best benefit, which would still be true in this court, in this particular instance that Sale has presented, where we felt it was in the people's best interest for Carthago Nova to be taken by us and not to have Indonesia on two borders with us.
I am going to sustain this objection, but only the first half, because the second half got into a bit of muddy water about being a counter argument. The clip did omit the fact that there was new evidence, that there was new situational requirements that were not present at the time of the legislative decision to declare war. Therefore, the possibility for the ministry to have to override that declaration of war and protect Arabian interests could be argued for.
Can we move on now? It's kind of going slow, guys.
I believe that the defense should have a turn. I still have some arguments, but I've said enough for one turn. In that case, we will now move on to the defense counter argument for this whole set of evidence here.
The defense is pinging a handful of people to see who's around. We have an extensive witness list, but I did that on purpose, knowing most of them won't be here. Obviously, WesGutt is on that list. I would like to finish with him or have him later on, because I know some other people have time constraints. So let's see.
Ken, I would like you to start with any counter arguments concerning the most recent bout of evidence before we begin calling witnesses for you.
Absolutely. I just wanted to ping them so that they were aware.
Absolutely.
I guess the counter argument here really is what I tried to say in my objection. First of all, we weren't acting in the best interest of the ministry. It doesn't benefit the ministry to necessarily have more cities, but it does benefit the people of Arabia if they do not have Indonesia, a potentially hostile enemy at some point, a potential hostile enemy at some point, having to share with Arabia. The whole legal discussion here in context was, what do we do to prevent our people from being at threat from Indonesia? The argument of maybe we can take it and fight it in court was one option. We could take it, we could back was another option. We could not take it at all and get it we thought at the time was legally a fair trade. We did not see anything wrong with that legally at the time. And I think to assume the motives that we just want to warmonger.
Objection. The interests of Arabians are not objective and cannot be assumed.
Well, if the interests of Arabians are not objective, I must ministry objective.
Could you restate that? Your mic was cutting out.
I must then ask if the interests of the Arabian people are not objective. How can the interests of the ministry be objective?
Yeah, objection overruled unless there's further argument. Or I'll let her speak, and then count. The ministry are a much smaller group, so it is possible to discover their motives without broader referendums or other methods of
Speaking.
I would
As
then
public-
again object and say that the broader referendum on the state of Carthagonova probed effectively that 98% of Arabians, 97% of Arabians wanted Carthagonova to be inside the empire.
All right, I'm just gonna go ahead and overrule this. Ken Lane, please move on.
Absolutely. I would now like to call to the stand John the JellyFish.
John, please enter voice chat and
I am
prepare to
already
answer
in voice
questions. All right, John,
John.
do you swear to tell the truth, the whole truth, and nothing but the truth? So help you whatever deity or moral code you please.
I do.
Then I now
Lovely.
pronounce you man in life. I'm sorry, I couldn't help. Anyway, John, you were a minister at the time, correct?
Yes.
What do you remember about the ministry having discussions surrounding the legality of Carthagonova throughout that term?
I remember we did that. This wasn't the voice chat beforehand, but I remember before that we proceeded with small discussions about it.
Would you say that WesGutt and I essentially facilitated discussions amongst the ministry?
Yeah, I would say that.
Would you say that the ministry was kept up to date on the legal plans surrounding Carthagonova?
I would say if the ministry was adequately informed.
Thank you very much. I will rest on this witness.
All right, Miss Sale, please go ahead and make your question.
Actually, can I ask one more question?
Yes, go ahead.
Would you say that there was malicious intent for us to keep the city irregardless of any possible outcome?
No, I do not believe so because there was talk about it, the referendum, rather than just ignoring the court order.
And would you say the talk about the referendum essentially surrounded the idea that if the referendum fails, then we fail to keep Carthagonova?
Yes.
Thank you. Now I rest.
Love. John, was the lack of responses to questions of legality mid-session part of the
I was not in the stream. I only watched around the last 20 minutes when I caught it, so I do not know.
So to what extent were you aware of these legal
I remember knowing that there was a plan to do this before session, and I believe I cannot say fully whether I was well if I knew the full extent of the loans, but I knew they were there. Yes. I believe that Ken's platform is a mixture of religious fanaticism and I'm not entirely sure if it's pro-military, but it's somewhere esque around that. And meme platform is quite clear. It's environmentalism with a theme of militarism. I would say that. Actually, I would like to say that I would only call Wes pro-war. I would say Ken will be somewhere in the middle. I was not a part of me at the time, but I am now. I would not say he gained a political advantage because I believe that the impeachment trial did hurt him because in the end that's how we all become prime minister because he was hurt by the impeachment scandal.
But
From the referendum results, I would say that it was broadly popular.
thank you, Miss Ale. I would now like to allow. Well, first off, I'm gonna allow any. Would anyone like to motion for a recess at this time, seeing as we're past the 1 hour mark?
I believe we had discussed recesses at the 90-minute mark, giving us another 15 minutes.
Yes, we had, but you know.
I guess I will motion for a 5-minute recess so that we all may use the facilities.
Absolutely. I have granted a 5-minute recess. Please come back with a less full bladder. See you all at 3:48 Eastern Standard Time. The time is now 3:48 Eastern Standard Time. The impeachment hearing is now back in session.
Thank you, Your Honor. And if you hear a cat meowing, it's just Sam. Don't worry about it. I would now
Thank
like
you,
to
Sam,
call
for
to
your
the-
input.
I would now like to call to the stand Chief Daddy Box.
Yeah, I'm here.
Chief Daddy Box, you were there for the after discussion on the date.
1 second, I gotta swear him in. Sean, do you swear,
Hold on. I don't. Please refer to me by my title, please.
Chief Daddy Box,
Thank you.
do you swear to tell the truth, the whole truth, and nothing but the truth, so help you whatever deity or moral concept you...
No.
Well, I guess that's just that.
Yeah, I'm going to tell the truth. Go ahead.
Okay, Ken, go ahead with your question.
Chief Daddy, you were there on the date in question for discussion after the session, were you not?
I was.
And what was your role in this discussion?
I guess I initially came in as the representative for the Supreme Court. Very loosely, nothing was, officially appointed. I just sort of hopped in because people were freaking out in the chat about it. So I came in to see what was going on and to yell at Wes. And then...
And what did you yell at Wes about?
Being a twat.
Could you remember any more of your words specifically?
I think I was pissed that he was taking... I'm trying to think specifically what I was mad about. I was mad that he was ignoring, the order of the Supreme Court, and more that he was damaging our institutions as a whole, as opposed to just... It wasn't so much the individual action, it was the damage to the institution as a whole.
Would you say at the start of this discussion you were vehemently against the idea of what the ministry did?
Yes.
Would you say that the ministry that were present, namely Wes himself, presented you with a series of arguments that led to that maybe it wasn't as bad?
So I think, and as we kind of discussed a little bit, the individual action like that you guys took, right? I still have a problem with, but the arguments for why you took that action were not as... Basically, I guess to rephrase what I'm trying to say here is that you guys had options available to you that would have been viable courses of action that weren't just ignore the ministry, or ignore the Supreme Court. But I do think that there were legal arguments that allowed you to take that route, if that makes sense.
I guess, if I can rephrase what you're saying, what you're saying that we had legal arguments that we could still follow and pursue, and that you really just wish we had pursued them more diligently before the stream had actually started?
Yes, that's a better summation of it.
Were you aware that our appeal had been denied merely that morning before the stream, and that there had not been ample time to fully vet an entire court case surrounding a referendum that had not yet leaked?
Yes, I was.
Okay.
Okay, no, go ahead.
Would you say that in general the ministry was acting in good faith in an attempt to enact the will of the people, or do you believe that at the end of your discussion you felt that maybe we weren't acting in bad faith, at least a legal gray area, if not in good faith?
I wouldn't so much say that you guys were acting in good faith, but I think that you were operating in a legal gray area is a better way to say it. Because if I may interject a little bit of my opinion on it, there was definitely some bad faith in that it was, you knew what you were doing, but you had enough legal wiggle room that I don't think it was outright illegal.
So you're saying we didn't act outright illegally, we were operating illegal.
Exactly, yeah. There was definitely a little bit of a legal gray area there.
Thank you very much. I believe I am done with this witness for now.
All right, does the other guy need to ask me anything?
Oh, lady is so gonna cross-examine you.
All right,
Oh, this is gonna be good.
give me 2 seconds. I gotta wipe my daughter's ass.
Okay.
This smelly shit, Charlotte.
It's not
Thank you for
Charlotte,
doing
it's
this. I
baby
know you're
Lennon.
busy.
Oh, excuse me, baby Lennon. She's not a baby anymore, Wes. She's 4 years
Sorry.
old.
Toddler Stalin.
Yeah, that's correct.
Changes with her.
Oh, that's a big turd. Okay. God. All right, sorry.
This is
It's-
all of the utmost legal relevance.
Hey, listen, it's not a Democraciv session if my kid doesn't interrupt it at some point.
It's very true.
All right, so I'm back to my computer, so go ahead. Fuck me over.
Sean, could you expand on the legal options available to the ministry?
Yeah, sure. So if the ministry had wanted to, they could have pursued an injunction against enacting the Supreme Court's decision. Pending the referendum results. I would say that's the primary like course of action they would have been able to pursue. The problem becomes that the injunctions can only be granted in conjunction with a court case. So they would have had to file a case. They would have had to wait for the justices to vote on hearing it, and then they would have been able to ask for the injunction. But they were also out of time for their mandatory play session. I think that's where we were at. Yes. A brief summary. The question for everybody is, when filing a case, are you required to present the entirety of your legal argument or just a brief summary? The court only requires a brief summation of the facts, not even your argument. It's just, this is what happened, this is what I'm suing against. So neither is the correct answer.
You discussed the arguments the defense had after their session. Do you believe that they had enough information to file?
Yes.
Does the court allow a case to be scheduled after a delay to allow parties to construct a more full argument?
Yes. The court traditionally will ask both parties when they'll be ready, and then they'll go ahead and schedule the hearing for that date. There's no upper limit on how far out a court case can be scheduled and how long a case can wait to be scheduled.
legally speaking, if the previous ministry had filed a case and asked for an injunction before the session, what would have happened next that would be different from what?
Provided we could get the justices on. Let's take the steps as if all 5 justices were available to vote on the injunctions. If they voted on the injunction, or excuse me, hearing the case and accepted the case first and foremost, and then they took time to vote on the injunction, depending on the way the injunction went, either the ministry would have been told to await the results of the referendum, or more than likely just not give back the city. If it went against the injunction, the ministry would have been told to give back the city. Just kind of depends on which way the injunction goes. And I'm not in any type of position to speculate on which way that would have went. I was just one justice. Yes. Both me and Nim were active during the stream.
Later half of the stream.
Yes. I mean, I was always around, but I was not actively in the chat or anything. I believe Espresso was around as well, but not consistently. Incorrect. I was not actively watching Discord. I became active because I was pinged about the situation. Going on. So yes and no. I would say no. The thing about it is I'm hesitant to say anybody was active because sure, we can say that. I'm hesitant to say that though because the justices last term were historically inactive or kind of ignoring cases and pings. So it just kind of depends if something spurned them enough to get on. Just for everybody who can't see, she said, okay, so 2 justices were available without being pinged, and 1 after being specifically pinged.
The text is on the stream.
Okay. Okay.
Thank you, Sean. You can go deal with your.
I'm sorry,
lovely
I would
house
actually
elf.
like one quick cross examination here.
Go ahead.
You may. Yes, do it.
Sale has brought up the point of an injunction, and I would like to do a quick reading of the Injunction Act and ask Sean a quick question. So an injunction isn't, this is from the Act now. An injunction is an order for somebody explicitly not to do something.
Yes.
This is considered an extraordinary measure and must be used with extreme caution. An injunction may never be used to order someone to do something.
Correct.
Is that not contradictory?
Probably. I mean, if we really got into it, yes. But I think that it's poorly written, but we all kind of understand what it means. It means an injunction can't tell you Ken to build a building, but I can tell you, the court can tell you not to build a building.
But
So
let
it's
me
poorly.
ask you this.
Go ahead.
Is an injunction ever in that body of text required for somebody to not do something? Is there a requirement for the ministry to seek an injunction to defy a court order in order to do what they think is legally the correct thing to do, irregardless of pending court cases?
Well, so there wouldn't be pending court cases at the time. The court case was resolved, and you had gotten what?
That's not the question I'm asking.
Well,
Is-
but I'm
It
answering your
specifically said
question.
irregardless. So
I
But-
did say
but-
irregardless.
You said irregardless of pending court cases, and I'm saying that's
Pending or non-pending court cases. Is
okay.
there a reason that an injunction is absolutely required?
Yes, because at the time
Where
You had a-
in the
you
where
had a
in the
court order.
Constitution? Where in the Constitution?
That was the
does-
second part of my question. What my answer was going to be.
Go ahead.
At the time, we believed that the court could give those orders. I still think they can, but it's not in the Constitution. So, if we're going off of that, then yes, you needed a court or you need an injunction to not do something that was ordered by the court.
So, under an interpretation in which the court is allowed to define rule of it being allowed to force other branches of government to take actions, that court order is legal. Is that what you're saying?
Let's not. You guys were the ones breaking. I guess tradition.
I'm not accusing you of breaking anything.
It's not like the court had just pulled this power out of its arsehole. Traditionally, the court has given these rulings down throughout the entirety of the mark, and it was a
legal tradition. It was a legal tradition, and it was
something
explicitly written.
What? Okay. Sorry, what were you saying?
So it's a legal tradition, and it's not explicitly.
Sure, it's never.
So we didn't break the law; we broke tradition.
What exactly is the tradition you're referring to? Because I don't believe there's been any.
There is. I mean, Wes, once again, I'm going to tell you what I told you at the other time. Don't be so dense. You're smart enough to understand.
Traditionally, Your Honor, he's badgering the whatever Wes is, the lawyer.
Okay. Objection. Fine.
I'm just
I didn't
saying
say it.
there has.
Sustained with the witness, please not attack the lawyers and just keep within the bounds of questions and testimony.
Sure.
And then to Sale's objection, just don't insult the witness.
I don't think I insulted
also,
him.
Yeah, don't interrupt answers.
Okay,
Please keep
I'm
this
sorry,
to
Your
one
Honor.
person at a time. Thank you.
You're right. So what I'm saying is that throughout the entire
This is all off the record now, so we can just.
They can hear you now.
How y'all?
I had a shitty golf game today, guys. I want that off the record.
I think that they could hear. So what I was saying was that we know traditionally if a argument or a case is brought before the court has issued a ruling and then given out some sort of remedy for that ruling. They've traditionally, I guess, been followed. If you want to say that, we've acknowledged the power of the court to do that implicitly with following these court orders.
But
there is nothing in writing within the Constitution. To your follow-up question that I know is coming.
I'm going to follow up with the question anyway so that the audience knows what it is.
Okay.
But there is no law that we are actually breaking here. We are breaking with tradition.
Yes.
Thank you. I will now relieve the witness, and I will offer him several badgers as compensation for my badgering or something.
No, that's okay. I don't mind.
Ms. Sale may now ask further questions.
Yep. I am at your disposal. I've got nothing better to do with my...
You have a daughter who's... You've heard this entire time.
Hey, listen, she turned 4 yesterday. I don't want to hear it.
Happy birthday.
Well, it's not my birthday.
I'm telling it to her. Can she hear me?
Yep. No, she's in the living room playing with her Barbie dolls. She got a Barbie doll ambulance.
What is the responsibility of the Supreme Court written in the Constitution?
I think the wording the court uses is to resolve disputes between branches of government arising under the law.
Shall be
I am
responsible for all cases in law arising under this Constitution.
okay. Yeah, that's the actual wording the Constitution uses, not what I
Thank
said.
you,
What Wes said. I'm not looking at a Constitution, so
God, the justice doesn't know the Constitution by heart. Come on.
The chief daddy does not know it. And Wes, could you repeat that, please?
Sorry. The judicial branch shall be responsible for all cases in law arising under this Constitution, the laws of the Arabian government, and controversies between the people or the people and the government.
there you go.
What is the line for the executive branch?
I don't believe they do.
I'm not sure what you really are referring to.
Is there a clear line of responsibility, I believe is the question.
I'm not sure what you mean.
Oh, does the executive branch have the power to resolve disputes between branches of government or otherwise interpret the law?
Yes, I mean, yes. They obviously the executive branch has to have the power to interpret the law. Every branch of government does. They don't have the power to resolve disputes between branches of government. But to say they don't have the power to interpret a law is disingenuous, because how do they execute the law if they don't interpret it? Yeah, I got it. No, yeah, you're right. That's a better summation of it. Is it still on the thing, or do I need to read it?
It should be on the street.
Okay, then yeah, that's a better. That would be incorrect. They obviously don't have the power to decide which interpretation is valid. Well, that
If there's
no.
a dispute, which there's a dispute.
Well, I think that's they don't have the power to decide which interpretation is valid in a final manner. Obviously, they can decide what they believe is a valid interpretation in the moment. But yes, if there is a dispute, the Supreme Court is the only branch of government that has the written power to decide the correct interpretation of the law.
Would you say that the executive branch noticed there were multiple interpretation of the law and then attempted to resolve the dispute by determining which interpretation was valid?
I don't know how to answer that. Let me reread it. What did you say? To resolve the dispute by determining which interpretation was valid themselves. I don't think so, but yes, maybe. I don't like the way. Can you reword the question so
Yeah,
I can?
that makes no sense.
Yeah, it's very tough for me to answer with that wording.
I'm going to object because Sale is questioning the motive of the ministry, and this is not you know what, I'll allow it. Never mind.
It's not a minister. No, he's right.
You don't get to say I'll allow it. That's my job.
He's questioning the motive of ministry through a court justice. This has nothing to do with this witness.
But
I guess Wes and I object then, yes, on those grounds.
I don't
object for myself. Thank you very much, Ken.
Wes can object
to their objections.
Witnesses may not object. Please.
I'm also a lawyer.
Shut up and deal with it.
Sean is also my lawyer. No.
Wait,
Sean is actually a lawyer for the prosecution. Yes.
Sean, would you like to object?
No, I'm not serving in a lawyer capacity right now. I am a
Okay.
witness.
I mean, you are
can't.
under oath, so.
But I did
um,
say no.
What were the objections again? That got very.
Permission to treat the witness as hostile.
Hey, the
Kenlane,
defense
you aren't even
can-
asking questions right now. The prosecution does not have permission to treat this witness as hostile, as he is part of their lawyer team.
Well, I'm gonna do it anyways.
All right, so Wes has objected on the grounds that Lady Sale is asking Chief Daddy Box to speak to the motivation
Okay,
of the
no.
ministry.
Lady said, "Can we
something
scrap
which-
this section?" I literally don't know what we're talking about, so we'll just move on.
All
Yeah,
right.
let's
So, Miss Sale, do you have further questions regarding this?
No.
Okay, Ken, would you like to bring this?
No, Sean
Okay.
has done his due diligence. Let's.
In that case,
Go
Sean,
white
you
poopy
are permitted
diapers.
to run screaming from the courthouse.
Well, I mean, I guess I should probably stay.
He lives in the
But-
courthouse.
Yeah,
Fair. Anyway,
I'm gonna go take
I-
a really
I
long
would
dump.
like-
I think
Lovely.
we're in his living room, actually.
We're in my bedroom, you asshole.
Oh, sorry.
Okay, gentlemen, let's get back to the task at hand.
anyway, would the defense please call their next witness?
I have not heard from Charsarian, JP, whatever his name is. I am DMing Charsarian now, but for JPJ, JP, JG, Gallarde 001, I would like to submit a screenshot of a conversation that we had in lieu of his testimony. Yeah, thank you, Sale. I don't
I
think
call
I
him
can pronounce
J-Gal.
that.
I think J-Gal's good.
That's what we call him over in the ASG Discord.
So I just want to submit this screenshot, which is testimony. It's not testimony. It's what we discussed.
This is not sworn testimony. This is a discussion.
This is a private discussion. Exactly. I asked him, "Were you there for the start of the stream?" He says, "No, he was not." Where were you? Discussion about the ruling. Did you vote in the decision on the trading of Carthagonova? And he says, "No, he didn't. None of the above." He essentially wasn't there. He was 10 minutes late. He missed the whole keeping of Carthagonova, and yet he is still a defendant of it.
Yeah.
So
This is just to
I'm
show
just
the
tossing that
legislature
out there for the
that,
legislature.
Yeah.
Um,
Suing this guy stupid.
So, Ken, you have made an argument regarding this. We will permit Lady Sale to make an argument, and then you will have final say on this piece of evidence, as it is evidence and not sworn testimony.
Absolutely. I'm sorry. I just wanted to.
Understood. It's fine.
Sean wants to do this.
Yeah, I'll while Sale's typing, I'll go ahead and throw out, because just for those unaware, I'm actually also on the legislative council. But Jay Gallarday is, correct me if I'm wrong, his proxy voted for him, correct?
I believe you're actually wrong. I
don't think
inside
there was no proxy
discussion-
present for him.
There was no
there was
proxy present?
The only proxy was
Interesting.
Excellent, who was proxying for John.
Okay. Did we record a vote for Jay? I'd have to
recall
look at.
perfectly. I may be wrong.
My understanding of the situation is 10 minutes late, and then he had trouble getting his mic working.
I definitely know Jago himself was not there.
He was not there himself. Yeah.
Okay. All right, then I'm good with what Lady Sale says.
Ken, would you like to have the final word on this piece of evidence?
I mean, I agree with Sale. This was just a step in the procedures. He should not be tied in with the likes of myself.
Understood. All right. You may move on to either another witness, or you can just.
I would like to call WesGutt to the stand.
Cool.
All right. Wes, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you whatever deity or moral concept you... I butchered that.
I don't know. You did butcher that. Can you say it again for me?
Wes, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you whatever deity or moral concept you please?
Sure.
I'll take it.
WesGutt, I just want to start by asking you, what was your legal reasoning? What was the legal reasoning we discussed throughout the entirety of the saga of Carthagonova, from the first acquisition of it via a trade to the final ignoring of the court order?
Every legal argument we discussed?
Well, like highlights.
Um, so basically, it proceeded. When we first got it, we thought it was okay because we didn't take it. This was before Lady versus the Ministry decided that the city was occupied based off the La Haas Convention. So at first we thought we were fine to have it because we didn't take it in war, like the Punic War Act explicitly forbidden. After we lost Lady Sale versus Ministry, our next argument was displayed in WesGutt v. Punic War Act, which is the legislature can't force us to sell a city, which is what it was basically what the justice had interpreted that it was doing by enforcing us to sell the city back. After that, it was the fact that it was the argument displayed in the appeal, which probably should have been its own case, that if we had given the city back, there would have been a state without any cities, which can't be a thing as per the Constitution. And then when the appeals court questionably rejected that, we moved to the next main argument we had was that there was a pending referendum that was after the Punic War Act, so it takes precedence, arguably. And I mean, really, that's the main thing. It takes precedence. It's
Okay, so now
equally law, equally valid.
If that's the end of your answer, I'd like to ask you: was there discussion before the stream with you, me, and the other ministers about where we stood legally with Carthagonova?
I believe so. We definitely talked about the case a couple times throughout
Did
the
we
entirety
talk?
of all our cases.
Did we talk primarily privately, or was there also? Actually, it's not an or. Can you acknowledge that you and I both previously spoke privately, as well as you spoke to other members of the ministry, and I spoke to other members of the ministry privately about the case?
Yes, I believe that'd be accurate.
And can you state that we had a discussion before that stream inside a voice chat before Pep showed up, where we discussed the legality of the case?
I believe so, yes.
Yes. Do you remember any details from that discussion?
Not particularly, to be honest. I'll admit I may have been under the influence.
I'll admit I may not remember that much as well, despite possibly having led that discussion. Anyway, I want to move on to the session itself. During the session, Lady Sale has attested that there was a lot of quiet mumbling going on, dodgy questions, things like that. Can you address for me why it seems like the ministry was so out of sorts?
So for the mumbling, my mic is broken, so that might just be it's quieter than I think I am. Definitely wasn't intending to mumble, but the mumbling in the beginning, when Peppeghetti asked a question and I said "in a bit," is what I believe I was saying. I was just getting our basic ministerial duties out of the way, moving.
Can I
ships and
ask a
such.
quick question before you go back to your answer?
Sure.
When you're playing the stream, one of the things that came up is that you seemingly moved on to moving stuff like that. Can you tell me why it is that you do that necessarily?
While I'm streaming, I've been streaming a lot this month, so I kind of just have the system of I'm trying to get the entire turn done. I'm trying to push the sessions forward. It's not about ignoring anything. It's just getting the stuff done so we can get it out of the way and then talk about the. In this case, it was get this stuff out of the way and then we'll talk about Carthagonova because that was obviously the big question.
So you're saying you're just trying to keep the stream moving. You're trying to
Yeah.
happening. You're trying to keep people interested in watching, as opposed to
Get
motionless.
moving.
Yeah.
So, for example, the prosecution accused me of changing the subject when PTP brought up a question about if we were, I think, something about us not being able to ask for compensation. I was, I believe, handling production in a city, and then I wanted to move into. I had noticed and I had wanted to bring up that Germany, we could have had a research agreement with Germany, which is a good thing for our nation. Stuff like that is what I'm trying to get done in this session. So I kind of just brought that up so we could get it over with. Yeah.
And so, where do you remember where exactly was the clause that we had to return Carthago Nova for free? And when you vaguely became aware of the fact that we had made a mistake at the start of the stream?
Can you repeat that last bit? Sorry.
Uh, where do you so do you remember where it was stated explicitly that we had to return Carthago Nova free? And do you remember when in the stream you became aware of this realization that we had made a mistake earlier on by trying to seek compensation?
I was made aware whenever someone like brought up the exact quote. I think that might have been Peppeghetti. I do not fully recall. But to the point of where this specific, where it's said that we couldn't ask for compensation, I believe what I was looking at to determine, this might be on the stream, I do not recall. I was looking at the court decision for West v. Punic War Act, which said it sustained Lady v. Sale, or Lady Sale versus Ministry, sorry. So if I recall correctly, the no compensation thing was within her initial comment when asked for what was it? What she was seeking from the case. And that was like the only time it was mentioned, as far as I'm aware.
And what happened after the ministry generally became aware?
You've been objected to. Could you restate?
That's what I recall. It could have been
Okay.
stated again elsewhere, but
Miss Sale,
that's
could
the only
you
one I
post the exact statement that Wes allegedly said that was untrue?
And that's what I'm referring to. What remedy are you seeking? Yeah, that's what I'm saying. That's the only place it was mentioned, which is like if you're in the folders, it's going down and down.
I'm sorry. This says the city be returned to Carthage in exchange for monetary reparations. Is that not what we did?
No, 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 no. Let me clarify.
Yeah, it was in a comment of this, right?
You stated that the court upheld my suggested.
Yeah, this is what I was referring to. I'm sorry if this was unclear. The comment, as I said, within this. Carthago Nova, as anything, as such, the ministry should return the city. Wait, no, not even that. Yeah, what are you talking about? I thought it was like in a comment or something. I haven't brushed up on this in a minute, sorry.
Lack of homework is not grounds for perjury in this court. However, I think it's important that we have all this on record. While Wes stated
Could
that
you
the
like
court
show
went,
exactly where it's saying? Sorry if I'm the witness asking for shit, but
or you're technically a lawyer. I don't really care if you're under oath at this point. We'll take it. Just don't object. The court stated that it had to be returned without reparation. Ms. Sale asked that it be returned
yeah, where was it?
with
stated?
reparation.
'Cause
I
remember even if you went to the opinion of the full written opinion of Lady Sale versus Ministry, it just said upholds whatever they asked for or something along those lines, if I recall correctly.
I'm actually looking for the case right now.
Yeah, I would really appreciate it if someone could post that opinion
Oh!
in.
Wait, is that the
Oh.
one where we? No. Let's see. Sort by new. Field. Why is it so hard to find court opinions?
You see what I mean? It's buried deep. It was definitely not surface level information that we weren't supposed to ask for stuff.
I believe this sufficiently. Sorry, I just really want to find it. I believe this sufficiently demonstrates the point I believe that WesGutt was trying to make. That. Sorry, I'm typing and trying to get this. That this is not necessarily easy. Why is it Reddit? What are you doing? This is not necessarily easy information to find. That oftentimes these opinions can be buried.
Yeah, that's basically the point.
Opinion of the court on Lady Sale v. Ministry. Christ, it's hard to find. All right, what does it say? Where the plaintiff seeks to have the city returned in exchange. If you just read this first paragraph, you get the impression that with the majority opinion, they're going to hold this. And then it even goes on to say the remedies sought by the plaintiff are within the Supreme Court's purview, and it has ordered the return of the city to go to Carthage at once. Item number 1, which should be 5, by the way, whoever formatting, under what was held. If you don't read any further, you're not going to find the fact that there is a clause somewhere hidden in here that I'm now scrolling for, that the city has to be returned for no money. If you have to scroll all the way down to the sentence. We order the ministry to return the city of Carthago Nova to Carthage for free, without anything else being offered or asked in first turn of the next session.
That's the only place where the
place
where the free part is mentioned. That's basically what I was getting to. It's buried. It's
so what you're saying is that it
One
was.
second. There's a statement from NIMB here. The court issued the following sentence in regards to WesGutt v. Punic War Act. The Supreme Court recognizes that the legislature cannot mandate the purchase or selling of cities.
No,
that power lies
it
with the
just
ministry.
it just says it upholds Lady Sale v. Ministry, the order to return the city. He retracted his input. So, Ken, do you want to continue with your...
It literally says the sentence to return the city to Carthage as issued in Lady Sale v. Ministry stands, in which Lady Sale v. Ministry were asking for us to return it for monetary compensation. Wes, I want to move on from this now that we have the facts out in the open about how hard it was to find the little detail that we weren't allowed apparently to sell it for free. What did you do when it was brought to your attention that we needed to end the stream because we had acted illegally?
Once, if I recall correctly, once Seanbox jumped in, Seanbox and I believe Char jumped in, as Justin said, shit's going down, hold up. All the ministers were like, okay, let's end the session. And we ended the session.
And we ended the session. So we weren't continuing to play.
Mid-turn, mind you. While there was some discussion while I was still moving troops and such, asking, I believe, Peppeghetti for production,
But we've already established this is how you move the game forward, correct?
Yeah, I was asking Peppeghetti for a worker instruction, and he said he didn't answer because of the questions brought up. And then
I have no further questions for this witness, Your Honor. I think he's demonstrated everything that he should.
All right. Well, now he has to demonstrate whether or not we believe him. In a lovely cross-examination by Lady Sale. So, yeah, your witness.
To demonstrate whether you believe me.
I believe it's the legislature who has to believe.
Fair. Details. Details.
Try to be a stickler in this.
And what if I step down and proxy for someone? You never know.
That'd be
Hey, I
sick.
could proxy for somebody, you know?
I'm going to encourage you not to do that.
You should have
Anyway,
run for legislature.
is
just so
moving
you
the
could
game
run.
state forward a higher priority for the ministry than following?
Sorry, the thought of us all running for.
I think that's a disingenuous question, but I guess following the law would be.
I object, and what relevance is this? How is it that moving the game forward is helping to break the law? The issue here isn't.
Sustained the actions of moving the game forward were in no way connected to the court opinion or relevant act. How many times did you submit a case or appeal to the court as a group? So that, Miss Sale, can you clarify which group that is?
I think it's pretty obvious. It's just referring to the ministry, me and Ken, more specifically. But yeah. The group was conferred with the Free Legal Arguments. So, how many times we submitted a case? We submitted West v. Punic War, and I submitted the appeal as well for that, which was questionably denied. And I guess Ken submitted a pretty shitty appeal to the Lady Salvia Ministry on some procedural grounds. So all in all, 3. 1 case, 2 appeals. Okay. Why is it that you did not include these arguments in your prosecution earlier or your defense in the initial case? In my experience, as Chief Justice for most of last Mark, I usually find it's best to contain a case to one central question. So instead of giving all 4.5 different reasons why we probably shouldn't give the city back, we started by saying, okay, well, the legislature can't force us to sell cities. And when that was shot down, or it wasn't exactly shot down, but when that case didn't fully get what we wanted, I guess, we filed the appeal on the no one state can have less than one city thing, and then we were going to continue with the referendum. So, to answer your question more succinctly, I did not include all of these arguments in a single case because it's best for a case to focus on one main question. To answer your question more succinctly, it's best for, I did not submit all of my arguments in a single case because it's best for a case to be focused on a single question. Instead of muddying the waters with 4 different ones. Why is that best? In my experience, again in Mark 5 as the Chief Justice for most of the Mark, I just found that when when plaintiffs would try to make cases with 4 different questions in the same thing, trying to give every reason why something might be illegal, it just muddied the waters. It's better to focus on your strongest arguments first. It's also harder for the court to decipher that, and that really just means longer rulings. West v. Punic War already had a pretty long, took quite a while. So if there was 3 extra questions on top of that, it would have been even longer. I was interested in as speedy as possible resolution.
So you held separate cases in order to make that case?
I separated my arguments for individual cases to go faster. Yeah. It's not the entire reason. I mean, you also don't use all your ammunition at once, but I guess. It's getting to more hypothetical reasoning.
Sale is asking, so consider that the legal is still
Yeah, I'm
benefit.
not really sure what you mean by that.
Okay.
Considering that the legal battle is. When I'm talking about the case, I mean like the specific cases, like the Supreme Court cases, WesGutt v. Punic War Act. That my intention was to make those go faster, but it's been drawn out quite a bit since then due to this impeachment. Pretty much.
That statement is in testimony and therefore
Yeah.
cannot be construed as.
I mean, what I said is what I said. It's pretty much just copying what I said. I don't know if you changed a word or two, but. Okay. Okay.
Your Honor, it has been another hour. I would like to that we let me go relieve my bladder.
Any cross-examination? I know you're
No,
happy.
I was
Any
reasonably
further,
happy.
Any further questions?
There exactly.
Can I
Any
ask
further
myself
questions?
since I'm also part of the team?
You cannot ask yourself questions.
Well,
I
I
can't
do have
ask
some
myself
questions.
At
questions
this-
on behalf of.
No, I'm
John.
sorry. I do have some questions. I should follow up on skills, but I kind of have to pee.
Yeah. Okay. So we will hold a brief. How does 5 minutes sound?
5 minutes, and then we keep Wes on the stand so I can.
5 minutes, and then it will be the defense's turn to question the witness, unless Miss Sale has an objection to that. All right, 5 minute recess. We will reconvene at 4:48 Eastern Standard Time. The time is 4:48 Eastern Standard Time. We are now back in session. The defense has called WesGutt to the stand. He is still under oath.
Thank you. Thank you for that little bit of a break there. Wes, would you say that your time as justice in the previous marks has made you a bit of a legal expert?
Sorry, I'm eating a bagel.
Would you say that I had consulted with you on the cases that we were bringing forward and we agreed to have a narrower...
I didn't answer your first question. Could you?
I'm sorry.
Could you repeat the first question, please?
Sorry, would you say that your tenure on the court from previous marks, are you a legal expert?
I would like to consider myself one. I have been here since... I've been here for like 4 fucking years. It's way too long.
I think we'd all like to consider ourselves one, except
Yeah.
some of us are just a little lagging.
Yeah.
Hey.
Would you say... I was talking about myself there, buddy. Would you say that was it true that I consulted you on all legal cases for the ministry and that we had decided on a narrow approach in order to make the question more clear?
Yeah, that was our general strategy going into it.
Would you say that quickness was never really an issue with...
I'm sorry, you cut out?
I'm sorry about that. Would you say that quickness was never really an issue with... Oh, god damn it. Did it again. Hold on. Let me turn down my thing. Automatically detect. No, we're going to go a little... Yeah, auto detect is a little bit too high. There we go. Would you say that quickness was never really an issue inside of the court cases, but rather getting a single judgment on a single idea correct?
That
was
definitely was a good goal of it, yeah. A big goal of it.
Would you say that it was less about trying to win a court case and more about exploring legal options that were available to us that we could make sure we were always doing the right legal thing?
That's always the point of a court case, in my opinion. Exploring the legal
I would
options.
agree. It's also why I would agree that we should have more court cases and not fewer. Why the court shouldn't be so unwilling to overturn itself and should be more willing to hear a case on an issue for a second time that comes from a new angle.
Objection,
Would you say that the
questions? Not
Sorry, I was leading you to this question. Would you say that the court was unwilling to hear the second case that we brought against it, against the Punic War Act?
There is definitely elements of the court who are very hostile towards any further litigation.
Would you say that several of those elements possibly should have recused themselves?
Perhaps.
Would you say in the appeals process, Masenko should have recused himself?
If I was him, I would have.
Why do you think you would have recused yourself had you been Masenko?
Because he defended one of the sides in the case.
Would you say that the timing was inconvenient to have a appeal denied the morning of a session?
Definitely was inconvenient, yes.
Do you believe that there was sufficient time for us to assemble a reasonable set of facts and arguments to present to the court in order to ask for an injunction?
I don't believe so. I think the initial filing is 80% of your case in most cases, and getting it right is very important.
I 100% agree, and that's why I did not actually file that morning. I don't believe I have any further...
Stop testifying.
I don't believe I have any further questions at this time.
Miss Sale, you may now proceed to question the...
Yeah.
Wes, would you say that someone who has voted against hearing a case should recuse themselves?
Not necessarily. Voting against a case means you don't believe the initial filing has much legal merit, but you still should rule on if you think it has legal merit, which is really what the final ruling is.
In what way were the justices hostile to your litigation?
I believe Justice Espresso, in particular, said multiple times that there was no way he would be she would be accepting any further cases on the subject. And I think Nim made similar arguments, if I recall correctly. Yeah, they're hostile to hearing any case in general on the subject. I don't want to say it was all justices. It was a significant amount of them, though. I don't think I said that. I never said anything about just as... No, I did not say that. I said that Masinko, since he defended a case, should have recused himself in hearing that and a vote regarding that case.
He did state that he believes some justices should have recused. I do not believe there was a statement of reasoning or a generalization made about when a justice should recuse themselves
Did I say that?
until the question about Masenko. If we want to go...
Could you read back my statement? Because I do not remember saying that. I may just...
I'm not.
I'm definitely high
I
right
don't
now,
think anyone
so
has
I
the
could be
minute to
wrong.
this. Hold up. Yeah, no. I have no idea what you said.
If you clip it on Twitch, you can get a certain specific section, but I don't know if that'll work.
Hold up. I'm not even signed in right now. I don't know how Twitch works. All right, chill.
Let me look into it real quick. Sorry,
Yeah,
I was.
thanks, Ken.
What was the question that? What's the question you're referring to specifically?
How do I get to not live? Yeah, I don't think there's a way to pull it right now, just because you're stuck. Okay, there we go.
You could just read back my statement. I'm sure I can clarify, because that's certainly not what I meant.
Yeah, I'm working on it.
If there's any other questions you want to ask while we find this out.
As Wes is looking for it, I will permit Wes.
I'm not looking for it.
As Ken is looking for it, I will permit Wes to object on the behalf of the defense.
I object.
On what grounds?
Ken? Give him a minute.
Hold on. 2/1956. That's the timestamp.
What does it say?
Sorry, I have to slow it back down. I was listening at 2 times speed to find it.
Oh, of course. All right, we're
Hold on.
almost there.
Let me
He's there.
let me transcribe this for you real quick. There are definitely elements of the court who are very hostile. Would you say that several of those elements should have possibly recused themselves? That's me speaking. Perhaps is his response.
Perhaps.
I asked directly about Masenko. He says, if I was him, I would have. Why do you think you would have recused yourself had you been Masenko? Because he defended one of the sides in the case.
Yeah.
And then we move on to talking about the session.
Yeah. So, sorry if there's a misunderstanding here. And then you're saying, said earlier that.
Sorry, does that work for everybody?
Yes, I believe so.
So the reason,
for the-
okay. So the perhaps is in meaning, if they are hostile towards the case just on the grounds that they don't want to see this litigated again, and not that they don't believe the grounds are correct, then I think then perhaps you should recuse yourself. If you think it's just in general you don't want to see it, not because of the basic, not because of the legal. What's the word I used? Legal. Yeah, I don't know.
I'm not sure if the word there quite matters.
I guess that's really up to the court to say you're suing this too many times, just give us all your arguments. But considering I only filed one case, I don't think that's really relevant here. So I really wouldn't agree with them if they said something along those lines, but I can't control the court. 4 cases. I would not count an appeal as a case. That's disingenuous.
Can you please specify what those 4 cases were?
I think he's referring to the Lady Sale v. Ministry, sorry, and WesGutt v. Punic War Act, and then the 2 appeals, 1 appeal each.
I'll point out I have to object at this question because it's misleading. Technically, the ministry only filed 1 case in order to keep Carthago Nova. The other case was filed by Lady Sale herself against the ministry. We never filed 4 cases on this.
Yeah. And one of those cases, no offense, Ken, was a stupid procedural thing. Like Ken explained earlier in this, that was done because he thought only procedural appeals could be done. So I don't really think.
Again, I object. 4 cases weren't filed. 2 cases were filed, and there were 2 appeals, one of which was merely procedural.
We're objecting over calling appeals cases, but I think that's clear now. So. Yeah. Any further questions?
I have no further questions, Your Honor.
Lovely. Do you have any further witnesses?
I do not. Charisarian is busy, so I am going to not call him today.
Okay. Lovely. Would the prosecution like to call anyone back to the... Well, you will have that opportunity if no one is calling any
Closing
further
statements,
witnesses.
perhaps. I think.
Ken, I believe you stated that you do not want to call anyone else up,
That is correct, Your Honor.
and no one has any more evidence to present. In that case, we will move on to closing. So, closing statements, we will start with Ms. Sale. I will read the statements off as they are. That's a lot.
He had this pre-typed.
Good.
Assume.
That-
Perhaps you should just.
Alright, well, I'll just read it very fast. We should consider it more closely that now the defense's argument about their motivation and legal reasoning. The previous ministry claims that their actions were in the best interest of the Arabian people, but we must ask if believing you are doing what is in the best interest of the people is enough reason to break the law. I would argue that most politicians believe what they want is in the best interest of the people. Notably, we have a constitution ratified by the people by a supermajority, which establishes the Supreme Court
4/7
as...
majority. Objection. It's a 4/7.
I said, second that objection.
Objection sustained. It was a 4/7 majority required to deal with that constitutional matter. I will continue reading this statement. Which establishes the Supreme Court as the arbiter of these issues, and the ministry has elected to ignore their decision based on their interpretation of these laws, on the idea that the Supreme Court was incorrect. Essentially, this argument claims that the Supreme Court is not the final arbiter of these issues, but merely a suggestion. What was the exact vote number?
They don't know. You would have to find the Reddit post. And perhaps here, maybe this one.
Exact vote number on what?
Announcements.
Oh, God.
Fuck. Ratty. Do I have to do the full word?
Far too many, in my opinion. I voted against.
I can't find it.
It was not exactly 4/7.
It was more than 4/7.
It would have been more.
And this is the most petty point we've made so far, so just fucking chop it. No one cares.
All right, that objection will be not exactly stricken, but the
Noted.
Constitution passed. Yes, objection noted. We're just gonna keep going. It was greater than 4/7. However, that was all that was required, and all that has been required to pass subsequent amendments, I believe.
Until we sign that 2/3 amendment, sign it now. Yay. I had to plug my own thing, sorry.
How many people need to approve that amendment?
I think like 4 or something, maybe 5.
You need 5 to sign it, and then you're going to need 4/7 of the vote to pass it.
Or will you need 2/3?
Well,
It
let's
won't
have
At what
Lady
point does
Sale
it
finish
pass?
her.
It won't be the Constitution until it's passed, and then.
Let's have Lady Sale
It's
finish her
required.
closing statement so we can move on.
Anyway. What is at stake here is not actually Carthago Nova itself. But the idea that ministers can ignore the court when they believe it is wrong without first engaging. If we establish this precedent, the court itself may as well not exist. And it is for that reason that I urge legislators to think carefully on the consequences of their vote. All right. Ken, your closing statement, please. Or Wes can do it if he wants.
I actually am planning to do it. I'm sorry, Wes.
Yeah,
You don't.
I might
get to
do my
talk.
own, but
If he's allowed to do his own, he's free to.
I can do whatever I want, Ken.
In closing, I want to say thank you again to everybody who has stuck it out for these 3 hours, to the legislature for watching this and coming to their own decisions. And I want to thank Angus M. Cromie, Guild Daddy, specifically for seeing over this. I want to thank the prosecution for arguing in good faith and doing the best of their abilities. And I want to thank them for actually making this happen on such short notice. I know we had other timetables in mind, but it felt like there was pressure to get it done this weekend, and I'm glad that we can finally move past this chapter in Democraciv. As for what the prosecution has attested in their closing arguments, they talk about the court being arbiters of the law, of decisions between branches. But I have to say, arbitration only works if everybody consents. If the ministry consents, if the legislature consents, if the justices consent, then the arbitration works. If there is still no consent from the ministry, from a branch, then it cannot work. If the ministry isn't consenting, then because they have another court case, if the ministry isn't consenting because they have another court case, then there is no final say. It isn't over yet. There is still a fight to be had. Furthermore, arbitration doesn't imply any form of enforcement. You can arbitrate as much as you want. That doesn't mean you have the power to enforce somebody to be doing the things that you want them to be doing. Arbitration is merely an agreement between parties to do things mutually. There's nothing that binds the party to do something they don't want to do in arbitration. And this is spoken to by Sean. He even said it himself. We aren't breaking anything that's written down. We aren't breaking the law of anything written down. We're just breaking with tradition when we ignore the court's orders. And keeping shit moving in the game, that's important, right? So that whole point just feels petty to me. The whole idea is Wes is trying to herd cats. We've seen it in this very session. We
That's
have gone
generous.
astray. I'm sorry?
Cats is generous. Continue.
Well, all right, fine. Anyway, we have seen it in this very session where people tend to go astray. We get onto topics about current amendments, whether things are 4/7. I don't even remember all of them, but we certainly went astray, and somebody needed to keep the procedures moving. That is a job. That is a job inside of this world that he is just filling. She also talks about ignoring the court, but we didn't ignore the court. We had arguments for the court. We had things to do for the court. We didn't try to not engage them. We just realized that at some point we have to sit down and play a session and engage them later. Look, what we did is maybe an illegal gray area, but was it wrong? Was it illegal? Is it worthy of impeachment? I don't think so. There was this whole issue I brought up in the opening about timelines. Cases were submitted, laws were passed before the ruling on the original case had been handed down. There was a botched sort of appeal, sorry, beer burp, to the case. We thought we had a clause in the Constitution that made one of the laws invalid that was ruled on in the case. We thought this, we thought that. We had a lot of ideas. We wanted to compartmentalize them to make them simpler and easier for the court to digest. The court became hostile. They didn't want to rule on this again, and I can't tell you why they wanted to not rule on this again. The court should be happy to have cases in this demo game.
Certainly preferable to nothing.
We did something. We made a decision, and we made it partly for the reason that if we gave Carthagonova back, there's literally no way to get that city from Carthage again without trading for them again or loading an old save file. There is no harm in the actual gameplay for us not to give the city back right away. There isn't. We can always give Carthagonova back next turn, the turn after, 20 turns down the road. But if we make the mistake of giving it back before we know for certain that that is what we're supposed to do, we have to load an old save file. And if that known certainty comes 2-3 sessions down the road, which it often can in this game because of the pace of the out-of-game things compared to in-game things, we may have to go way back and load an old save file and play through some turns that we had really done a long time ago. And finally, and furthermore, not finally, because I'm not done here, Masenko ruling on the appeal of a case that he argued in is frankly unethical. It's probably the one smear against his record, and he is an upstanding person who doesn't deserve to be dragged through the mud, but in this particular case, he acted unethically. He shouldn't be ruling on a case for appeal that he had already argued in. That's just common sense. That's law 101. Then there's the question, is what we did even technically that illegal? Is it really illegal, or is it just that we chose between two illegal options? Sean testified again. We didn't break any written law. We just broke tradition. Sale wanted some legal arguments up in the stream, and I get that, but at the end of the day, that's not how you win cases. We've had so many debates on Discord prior to cases that I feel like all my best arguments are being dropped out there and then picked apart in a case where they've had weeks to think about it, and I haven't seen as much from them. So I'm not really willing at this point to say anything other than eat my ass, or sorry, bite my ass is what I said. I should quote myself correctly. To members of the court and the legislature who may or may not be seeing us in court in a few weeks. You don't get the right to my defense. It'd be silly if I sent you the defense for this case. I'd be hung up by my thumbs by my clients if I did that. So no, I don't owe you a legal argument inside the middle of a stream. That's just ridiculous. That comes out in the court. We weren't acting as a rogue state. Sale has said this in the past, not in this case, but she said it in several chat channels. As Wes testified, we're merely trying to keep court cases short here. We weren't acting as a rogue state trying to just prolong the inevitable. We were just trying to keep things simple, compartmentalized, and easy to digest for the people that were trying to digest it.
Objection is sustained. You were called a rogue branch, not a rogue state.
My apologies. We were called a rogue branch. Please submit the entirety of what I said as if it was rogue branch and not state. Although I'm going to go back and check that to make sure. Anyway, as I was saying, we weren't trying to act like a rogue branch of the government. We were merely just trying to keep arguments simple, keep things compartmentalized. We were trying to make it easy to digest, and we were trying to work through all the legal possibilities of what was there, of what we could do to possibly not break the law once we realized that there was a conflict of law. Also, how did we even know we were breaking the law when we tried to sell the city back? We thought we were entirely compliant. The only place where it says the city has to be returned for free is on the very last page, page 7 of the court's opinion on the case Lady Sale v. the Ministry. That's the only place it says it. Lady Sale didn't ask for us to return it for free. Their initial pinging in Discord didn't tell us to return it for free. The summary at the top didn't tell us to return it for free. It was merely in section 4, which is not properly bookmarked apparently. It was merely in section 4 in the final point that it was pointed out we needed to return the city without asking anything being given or offered. Jay Gallarde shouldn't even be in this trial. The guy wasn't even there. Our witnesses, they all stated things seemed like they were on the up and up. The ministry was informed. There was no intent to just merely violate the law. We were just trying to figure out a way to enact the will of the people. We were trying to figure out how to play the game with a hand tied behind our back. We were trying to figure out how to play the game while we had ongoing court litigations. It wasn't us doing things maliciously. We were just doing what we needed to do as ministers to play the game. Look, if you expect that any proof whatsoever of us being guilty is all that you need to convict us, that's fine. But that's not the system that we should be aiming for. In most systems, you need a definition of what exactly guilt means. Is it beyond a reasonable doubt? Is it a preponderance of evidence? I don't know what it should be here, but I do believe that it should be beyond a reasonable doubt. Is it beyond a reasonable doubt that we merely didn't understand exactly what we needed to do going into that session? Is it beyond a reasonable doubt that we were acting in bad faith? Is it beyond a reasonable doubt that we were ever trying to subvert democracy or act as a rogue branch? I don't think so. And I think if you look at the evidence we presented, the people were on our side the whole time. Everybody agreed just about that we should keep Carthago Nova. 97% of people wanted to keep the city. Why would you impeach ministers for doing what the people want? Isn't that how democracy works? The people get what they want. We are subholding only to the people. Had the opinion been that we shouldn't keep Carthago Nova, I imagine several members of that ministry who are on trial today, namely PTP and WesGutt, would not have been reelected. Yet they were. In landslides, West tied for the most votes inside of that election, most first votes. So what's the deal here? Why are we guilty? What did we actually do that was that wrong? Is it really beyond a reasonable doubt that we merely were just trying to enact the will of the people? I rest, Your Honor.
Thank you very much, Ken. And just because I said he could, I'd just like to confirm with Wes that he doesn't want to say anything.
I kind of just a small statement, not to take away from Ken's wonderful closing statement.
That's fine.
Yeah, mostly on the point the prosecution raised about they were trying to paint the picture that by me trying to move along in the game, trying to get the actions, every turn actions done, that somehow that proves bad intent. I think that's just ridiculous. I was simply trying to do my job that I've been doing this entire Mark, even before I was in the ministry, I was streaming. I've been doing this since Mark 2, and I know I've been streaming since Mark 2, that is. Getting the game moving, making sure the stream isn't stalling, is one of the most important jobs of the streamer. It's really the main job of the streamer. And that's really all I was trying to do. To suggest that was somehow in bad faith to ineffectively brush over the arguments against what we did, it's just simply untrue. And yeah, that's really the main thing I have to say. So I rest.
All right. Seeing as we currently have 7 viewers in the stream, I'm just going to quickly ask if anyone watching right now has any burning questions. Any legislators right now have any burning questions? Just to make sure that we can get any necessary clarifications out. But then, yeah, we should, if that evidently isn't happening, which
If legislators could put it in legislature chat, that'd be best.
Just, but yeah, I don't want this to go past 5:30, so. And RB's typing something.
RB asks, why are you innocent? How can we acquit you more than possible? Just joking.
Based on the fact that the only question we've had from a legislator it
Says it's
ends in
joking.
just joking, I declare this impeachment
Wait,
hearing
wait.
over.
Okay, cool.
Is something happening that I
No.
need to know about? Hold on.
Nothing. Never mind.
Alright. I declare this impeachment hearing over. The legislature will now enter a 24-hour discussion period that will be followed by a 24-hour voting period. Please remember that the ministry must have violated the law without reasonable doubt for you to convict. Have a lovely day, and I'm gonna bang my gavel one more time.
Also, just make sure you acquit Jago, because he definitely didn't do anything.
Yeah, please fucking acquit that guy. Have a good night, guys.
Goodbye, and sign my amendment. Thank you, bye.